hate to hear from you taking long about when we're back on.
No problem. We are starting the stream now, and we are good.
Okay, so we are back in open session. At this time, I'll entertain a motion to approve the closed session actions that we just took.
Yes, sir.
Sorry. Motion's been made by Leslie Kessler, seconded by Dr. Paul Marcia to approve the closed session actions. And so we will now take a roll call vote. All those in favor say your name, yes or no, or abstain. Megan?
Can I stop you real
Yes.
quick, just to procedurally on those closed session? I think that when you decide to do something in closed session and come back and vote on that, you need to state session.
Oh, okay. I'll be happily doing that. So correction from our attorney, David Gabb, that we were back in open session and we're approving the closed session action items. I am to summarize what those items are. So in the closed session, we discussed the need for a summer intern. The executive director presented the need to hire a college summer intern for the purpose of consolidating all of our record retention reports, scanning those, filing them digitally, just really getting a handle on all the paper archives. And we approved a budget item to hire a summer intern. And to also elevate, excuse me, someone in our current staff into helping do the licensing piece of WA. The other thing we approved in closed session was we reviewed a complete listing of the executive director's performance appraisal with a consolidated report from the chair for performance in the last year. We, in closed session, approved an 8% bonus of $12,116 in recognition of our executive director's performance. Thank you. Yes.
And you can
Now we can do the vote. Yeah, do the vote. So now we can do the vote to approve those action items. Now that we're back in open session. Okay, we'll do that roll call vote. Please state your name, yes, no, or abstain.
Megan Wentz, yes. Tiffany Minor, yes.
Paul Garcia, yes. David Edwards, yes.
Teresa Hale, yes.
Rosa Gonzalez, yes.
Leslie Kessler, yes.
Stephanie Bernard, yes.
And so the motion carries with unanimous vote. Thank you all very much. And now that we have approved those, that bonus for our executive director, we will now turn it over to our executive director for her questions from the audience.
Okay, so the agenda item that says responses from PD, DB, and questions addressed at the previous meeting. This is now, I probably need to retitle this section, but it's really those answers that Debbie and I tend to get questions about at some point, but all the ones that are on this list right now are what the board addressed at the last meeting and the Public Protection Task Force is addressing. So, you know, if you had an opportunity to take a look at them, this is just noting what we did in between meetings. And I'm not going to spend too much time here, only because then in the next section, we'll go through the actions that we need to take on a couple of these again. So we let the public know that the board was going to continue to think about the advanced training position statement and the definition of that, which we have done, and you'll address in the next section. We've continued to discuss and come up with a position statement on internal public health. Finding and gaffing, you'll determine at the prior meeting that was not really within the scope of practice at this time, but that you know, somebody could be trained to do that, but it's not called or billed as physical therapy. Pes refittings was considered as part of the internal public health. And then perineural dry needling was also determined not to be within the scope of practice because that's not what the Supreme Court approved in its ruling back in 2018. So does anybody have any questions about what we had talked about previously? Then we can move on to the next agenda.
Okay. Then now the next item on your agenda is G, scope of practice questions. And before we jump into all of that, I'll turn it over to David Edwards, who is the chairperson for the Public Protection Task Force, for his update report.
Okay.
No, that's not it. I'm sorry.
You guys attached, and it's attached to your agenda if you want to review the minutes. Yeah.
Right, so, just in summary, we did have a meeting on May 26th. Myself, Leslie, Jamie, Rosa, our president, staff president, Kathy, David Yed, and then subject matter expert was engaging on our physical therapist. For our newer board members who don't know, she served on the board in the past, and she is considered an expert in the area of public health. Okay. So, with the pessary fittings, is everybody familiar with what a pessary is? Anybody that's not? Okay. So I did some research on it myself to learn more about it. During the presentation, Dr. Hunter really brought it down to a level that all of us could understand it. And the fact that it is something that with proper training, she felt was in the scope of PT. And so our thought on that is that it would be within the scope, provided that the PT was properly trained. The pelvic health position statement. You have a copy of that. I think, I'm not sure if everybody reviewed the draft or not. We have that.
Debbie and I can do that if you like. When it reviewed, we can do that if he wants to.
Okay. There was also the question of students and 41's health interventions. And there again, we've got all the details here, but the gist of it was that we said as long as the physical therapist supervising the student or the PT assistant were properly qualified. And we have the details of how those qualifications may occur through coursework, et cetera, then it would be acceptable. Now, if in regards to PTAs, if reassessment was required continually, then it would not be appropriate for a PTA. Now, we wrestled with, okay, initially, I don't think any of us really knew how much some of the programs do train and prepare their students to work in this area. And so a lot of information was brought forth indicating that this is an emphasis that some of these students do come out to enter into these clinical rotations having already been through coursework. And so looking at that, you know, our recommendation is that as long as the program coordinator, program administration ensures that the physical therapist intern student has been properly prepared, then it will be acceptable for the student to perform these activities under properly qualified physical therapist. There was also a question about the probes and so forth. And we did look at that, and if anybody's ever dealt with women's health, the probes and dilators have been around in use for quite some time. And so that's not anything new. The statement will be something to look back, vaginal and anal techniques are included in scope of practice for pelvic health evaluation interventions and proper education, training, and confidence. And it's okay. Kathy, do we want to jump to imaging or get the stress for the pelvic health first?
Well, I think what you want to do is ask the board if they agree with and approve the internal public health new position statement that was drafted, which includes pessaries and the anal dilators, vaginal sensors. And because those are all kind of a package of things that we've now combined as a new position statement or an updated position statement that we could do with grades or something.
And then we also provide vision statement 13 that we had another one about PTAs doing mobilization and therapy techniques, so that was combined into this one.
So does everybody have a chance to review the draft document, the position statement? Are there any questions or discussion?
I thought it was very well done. You know, our sessions were very helpful to give information and think about things perhaps differently than we had before. So,
Yeah, I want to congratulate the Public Protection Task Force for stretching your brains a little bit to understand an area of practice that you may have been very unfamiliar with before. And so I'm really pleased that you had a good expert person to explain all that.
Angela Hunter was a previous board member. I thought this would be so resource. So I appreciate her being reached out to me and making herself available to us. It's very helpful.
And so the new position statements, will they be appearing on the website?
After y'all approve them, yes, they will.
Okay, we will need to have a motion vote to approve these new position statements. Has everybody pulled those up? Are you seeing them? Hopefully you've studied those prior to today.
Yeah, they're on the, they're in the agenda, so we can pull that up. We have not, we haven't talked about the advanced training ones. We could do that also if you want to do just one motion.
Let's do that. Go ahead.
So we revised the advanced training, which was really intended to be a definition of advanced training, because there really is a requirement for portions of the scope of practice to require more than just an entry-level education. And let's talk very specifically about drain needling. And so in terms of that, even though there is not a board rule that says if you have to have this additional training, it is additional training is required because it's not taught everywhere in entry level. And so sometimes when I receive scope of practice questions, I have to answer with the words advanced training. And without there being a clear definition of advanced training, you may or may not understand what that means. So this is the updated position statement related to advanced training. We still refer to drain needling and internal pelvic examinations because they do require advanced training to obtain the skills to do it and and similarly, a student wouldn't do it without supervision, but we tried to broaden this out so that it could apply to everything. Those two things we just use as an example. And so, maybe take a minute, see if you have any questions about how we changed that. Or to shorten it up.
Be nice practice.
So I would
Okay.
consider those two things.
All right, so you have in front of you this revised definition of advanced training. As an understanding that when our ED is responding to scope of practice questions, it's important to state that this particular scope of practice requires advanced training. And so this is really to clean up the language of what is advanced training, what does that mean? So because we have, now we're looking at a position statement. We need to agree to that. We can accept all of these new position statements on everything from neutral public health to advanced training. So I'll entertain a motion to accept this.
Edwards' motion to accept position statements related to internal public health, industries, and advanced training.
David Edwards has made a motion and Rosa Gonzalez seconded to accept the advanced training position statement, as well as the student performance of internal public health as written by the EP. Any additional questions or editorial changes?
It's still in this advanced training, though leaves it doesn't specify how much coursework. It just says that they must get advanced training. When it even doesn't specify that it has to be necessarily through taking a course, right? It could be through self-study training.
Well, so we're going to talk about something that also may require additional training and in the next item. And what our belief is that some of that's going to need to be codified in the rule. If we really, if as the board believes that a specific amount or type of advanced training is needed, it's going to need to put in the rule. That advanced training is just a definition to help people qualify the fact that advanced training is needed, and then
It's just beyond like the normal course.
it's beyond entry level education. And while some programs are bringing in subject matter experts to do that additional training, because it's not throughout all the programs, you know, our rule, our permitted practice rule talks about routinely in education, routinely available in continuing ed, routinely performed in practice. So yes, it's available in continuing ed, yes, it's available in practice, but it's not consistent throughout North Carolina, which is how the board has interpreted that educational piece of it. And based on some of the things that we've seen come to the board in terms of complaints, you know, things that are really need very specific clarity around the advanced training will need to be codified in the rule. And so, but you'll kind of hear a little bit about that in a minute, related to the topic.
For a point of clarification, can you explain for the new folks and to answer Jamie's question, why our definition is so broad and the details are worked out through rules? Can you talk about what that means?
Well, over time, because practice is evolving and because we're getting questions that the board has not previously answered, techniques in physical therapy that are you know evolving as part of practice, and that are within the scope of practice, there needs to be an understanding that entry level cannot prepare you completely to be competent in something. Again, going back to the dry needling example, when Humro did the study several years ago on what you need to be able to be a competent dry needling provider, Humro said you have 86% of the skills you would need to be a competent dry needler in entry level. But that 14% is still missing. And so when we answer questions as a board, we also answer it with fairly broad language. And so we often use the term advanced training. And I feel like now we're kind of leaving it up to a general and individual's interpretation. And so it's helpful to have, what does advanced training really mean? And if there is something that's required for a specific technique, again, like dry needling, that's going to need to be codified in the rules. And if there's more specificity that needs to be provided related to internal public health, it needs to be codified in the rule or anything else. And, David, do you have anything you'd like to add?
That's good. So,
I would just say, when we read our position statement about the dry needling those years back, that was one of the things that the chiropractors, acupuncturist latched onto, was that we had been fairly prescriptive in the number of hours for the training, right? Like they went there at points, and they required 100 hours, and we were saying 39.
Yeah, and then the Rules Review Commission wouldn't pass it. But now we've been through the Supreme Court, who says, yes, it's within the board's scope to make those kind of decisions. And we will be able to go back and circle around to it. It was on the Public Protection Task Force agenda initially, but we weren't sure we were quite ready how to approach it. And I think we've got a better base for being able to do that now.
And then we will be required to discuss what the appropriate amount of advanced training hours is.
The Public Protection Task Force, kind of like today, is bringing forward to you their recommendation about internal public health and this definition for you to approve, so that when I get these questions in the future, or we can post it on the website, it's a consistent message that I can send every single time to get the question.
Good discussion. Are there other questions around these definitions, the board's position, or the position statements? So just to be clear, if the licensee calls the board office and talks to Kathy or emails and says, I need to know how many hours do I have to train in order to be certified as a dry needler, what will the board's response be?
Well, the board's response, first of all, is that you need additional training beyond entry level, and that you would need to perform only those things with which you have received additional training. So, now I know the programs are changing and they've integrated all parts of the body into one course with one particular provider, but it used to be that you go and you get maybe the upper quarter, and then you go and you get the lower quarter, and maybe the spine is a separate course. And so if you just did the upper quarter, you wouldn't be dry needling anything else beyond the upper quarter. I cannot say that there's a specific number of hours because we don't have a rule that says that. But I can say that they require additional training. Because, and the way that I frame it, which helps people understand it a little more clearly, is that if there's a complaint filed to the board about your dry needling, or that you harmed somebody with dry needling, then you need to be able to tangibly demonstrate that you have the skills, the ability, and the competence to do that technique. And part of that is by showing us the piece of paper where it says that you did obtain that training. That makes sense.
Yes. Any other questions for the ED? Are you ready for the votes? Okay. All those in favor of the motion before you to accept the position statement and the definition of advanced training, let it be known by saying your name and Aye, yay, or nay? Aye, nay, or abstain? Start with Megan, please.
Megan Wentz, aye.
Jamie Minor, aye.
Garcia,
David Edwards, aye.
Teresa Hale, aye.
La Rosa Gonzalez, aye. Leslie Kessler, aye.
Stephanie Bernard, aye. Thank you. The motion carries unanimously. Next on the agenda was an imaging update from the attorney.
yes, and this is also in the section of the attorney's report. I'll go ahead and address this now. Just to give you a little bit of background, the Public Protection Task Force has been looking at imaging for some time. And where the task force kind of was as far as progress on that was task force instructed myself and Ms. Arnie to speak with some of the other interested parties regarding imaging. So where we started was the medical board and the chiropractic board. So we had a conversation with their executive director and some other staff for those boards. And it was very helpful for us because what they suggested just in general was that we haven't run this by our boards, but before we even did that, what we would like for you to do, talking to us, is talk to some of these organizations within our board that may have a position, because that's what our boards are going to want to know before we give you any sort of response. So we had a long list of groups of licensees in the medical board that deal with imaging on a regular basis, and the same with the chiropractic board. So we were kind of in that process and trying to figure out how to address that, who to go talk to, tell them kind of what our thoughts were on imaging, particularly the fact that PTs don't have the authority to interpret the images, but we're talking about only ordering the images themselves, which would then be sent to someone who has the capability and training to interpret the images. So that was kind of in the process. And then right in the middle of that process, Kathy got a call from an attorney with General Assembly. And these attorneys are assigned to different members of the General Assembly. And the inquiry from that attorney was, hey, we've had a request from one of our members to address imaging. And what we want to do is submit a bill. We're in the short session, and we want to submit a bill that will allow physical therapists to order imaging. And we'd like to hear back from you within a week and a half on how this bill should look. So that sent us into complete scramble mode to try to come up with something, because we just weren't there. We wanted to hear from all the different interested parties before we came up with any sort of recommendation to bring to you as the board for your review. And then decide how to deal with this, whether it's by rule or whether the actual statute needs to be revised to include the definition of imaging within the definition of physical therapy. So we kind of did the best we could on a very short timeline. And just very briefly, what we came up with was a definition, and this was just all suggestions to the General Assembly. Of course, they can adopt whatever they like, but based on our suggestions, we came up with a definition of diagnostic imaging that basically reads, diagnostic imaging means techniques used to capture the image of a body part to assist in verification of the etiology of a functional impairment, assist in the development of a PT plan of care, and to determine whether a referral to another healthcare professional is necessary. And it went on to modify the definition of physical therapy, which included the ability to order imaging. But probably more importantly, it set out in our suggested version of the bill, it set out what a licensee would have to do to be able to order imaging. Just a brief summary. One has been issued a specialty certification from the American Board of PT Specialties, completed a residency or fellowship accredited by the American Board of PT Residency and Fellowship Education, completed a formal diagnostic imaging ordering training program approved by the board, as a graduate of the CAPT accredited organization. Has entry-level clinical doctorate educational program in physical therapy after 2016. Has completed education in clinical imaging from a CAPT accredited institution, including instruction in clinical imaging terminology, factors affecting resolution, quality, and interpretation of clinical imaging, indications and contraindications for clinical imaging, American College of Radiology appropriateness criteria, evidence-based guidelines for the application of imaging modalities in clinical response and follow-up on imaging results. So the licensee would have to do all of this stuff before they would be able to order imaging. Second, the licensee would have to annually attest on their license renewal that they have done all these things. So there would be like an additional section on the renewal, and logistics haven't been worked out, whether it would be a box or some sort of attestation requirement. And that way the board can kind of keep track of the numbers of folks who are doing this, and also have some sort of record that this person has tested that they met all these requirements. And then finally, and probably most concerning to us, was right in the legislation, there would be a paragraph that the physical therapist shall not interpret diagnostic imaging results. And the patient's primary physician or qualified healthcare professional shall be providing imaging results. The patient shall be referred to a qualified healthcare professional if the results of the imaging are deemed to be beyond the PT scope of practice. And that was it. That's kind of what we came up with in the short time that we had. That was then sent back to the attorney for the General Assembly. And then there was a deadline toward the end of May to get this bill in before, the deadline for all bills in the short session of the General Assembly. We monitored that, and it wasn't filed. And to my knowledge, nothing's been done since then. So what we planned on doing is getting back with the lawyer that corresponded with us and gave us the opportunity to give him input and just kind of figure out where that may stand. And they may not know, but that kind of brings you up to date. So we can go a couple different ways. Either a bill will be adopted, or we can go back to, if they're going to abandon this idea, go back to where we were through kind of the slower, more deliberate process to get some feedback from you before anything's done.
If I can add a couple comments to that. This was a fast and furious collaborative effort with David Gadd, Debbie Reagan, and myself. We were asked not to really share this with people. So, it was a little bit of an uncomfortable thing, because we had also talked with these other boards and said, we're going to get back to you and tell you what we're going to do before we're going to do it. And so in the end, I called them the day before the bill draft deadline, and they were extremely appreciative of the fact that we were being upfront and telling them what was happening, and that, this potential bill introduction wasn't coming from us. But yet at the same time, we had input into it. And so I feel great about what we came up with. I really do. And that's a function of all the board's commentary up to this point, all the public protection task force work, the input from guests that we've had, Mary Kay and other information that we've received. And so plus APA and C. And I think that, it's a product that you could be proud of, and we purposely didn't put it in the agenda because we didn't want it out, because that was sort of a request that we had been made of us. And the short session is really the budget session, so we weren't really sure whether it could be introduced anyway. But then the long session begins in January, so we'll see what happens then.
I just have, I read this for and when you read it, and then David, does it say Kathy accredited or?
Our version of the recommended bill.
Yeah, so I was just thinking about, I had thought about this before until I was, I was looking at the agenda and saw the person that said that that we discriminated against foreign training. Do we allow for that?
Yes, well, we didn't specifically say it like that. First of all, you have to be a licensee. So right away, they've already become a licensee. And if they came to the United States and took the most current, and this does say specifically physical therapy, graduated after 2016. So if they came to the United States, if they had a credentials review after 2016, the education about diagnostic imaging should have been a part of what they were evaluated on, whether their education was, Debbie, you stop me if I'm wrong there. But,
Okay.
but if you think we should add something, we should.
Well,
do
I
it.
just think, I don't want to get a situation down the road that says that we're, that somebody that's been here, practicing for a long time, and then they go and they do the fellowship course, but they didn't graduate from a CAFE accredited program.
Okay. We need to look at that.
So but I never thought about it. And then when you read it, I was thinking, well, I don't know that this particular claim of discrimination has it here, but it just raises the question.
When we get to that section, I'd like to talk
Yeah.
about that.
And it is that you satisfy at least one of those criteria.
Yeah.
Okay, so that was, I was trying
Yeah.
to sort out whether it was and or.
That's what, yeah, I was wondering if you, everyone or
Yeah,
how many?
okay.
You gotta satisfy it.
at least one.
Okay. I need to change
Good
that.
question. Good question.
And then, and I may have missed it, it sounded like imaging was left open and not restricted to x-ray, which we had
Right,
talked
right.
about. Okay,
The Public Protection Task Force kind of evolved their thinking on that. And so it probably, we probably haven't brought it back to the board as some written document for you to look at, maybe since that point. And I think where it covers the ground on competence is in the education that you have to obtain. Specific advanced education that you have to obtain.
And the training.
Well, so David might better do that about the statutory authority question.
Yes, so there's a question about, when you go through rulemaking, you have an opportunity for people to object. And the attorney for the General Assembly said, well, it's our opinion that you don't have the authority to include this in the definition of physical therapy without a change in the statute. Our rules say that if it is taught routinely in entry level, or I'm not sure how it's worded, I don't have it in front of me, but if it's taught routinely in PT training, then it's part of the PT scope of practice. So that's kind of what we were going on about this imaging idea. But it also doesn't specifically define it in the definition of physical therapy in our practice act. And to do that, you would have to have a change in the statute. So there is some question about whether or not, if somebody objected and says you don't have the authority to include this without a change in the statute, there is some question there. It's not crystal clear. An argument can be made both ways because it is taught in some degree in physical therapy training. So we've got that hurdle to get over. If there's a bill introduced, of course, that goes away because that would definitely cover it. But if we do decide to address it in rulemaking, we would need to be satisfied to ourselves that we have the authority. We haven't really delved into that all that deep yet, just because we weren't there yet in our process.
Well, I applaud our attorney and ED and deputy David to have come up so quickly with
a comprehensive look at, and approach at this issue that we all support and want to happen. So thank you so much for doing the deep work. This is not a position or anything the board needs to vote on at this time. This was really some very nice work that our staff, attorney and staff did. Thank you so much. The next item on scheduled practice, we're still in section G, would be virtual PT platforms, United Healthcare. So Kathy, do you want to ask that?
Yes. So there are, some of your colleagues out there, physical therapists that are paying attention to what is going on with, again, evolutions in practice. And United Healthcare has come out with an app called Kaya that they're calling virtual physical therapy. And this must have been rolled out nationally all at the same time. And in one day, I got 3 concerns / complaints about this. And then probably not too long after that, concurrent with one of the complaints came an APTA statement about this. And then what David's scrolling on the screen right now is not too long afterwards, the FSBPT, so our regulatory membership organization to which we belong, came out with what I thought was a very excellently worded letter congratulating UHC on utilization of technology in practice. However, in all 53 jurisdictions of FSBPT's membership, it is required that a physical therapist be involved in the practice of physical therapy. And there did not appear to be any evidence of a physical therapist involved with the use of this app. I had been asked to look into virtual PT platforms through some conversations that I was having with the Compact Commission. And so when you go and you just Google virtual PT platforms, what you'll see is a number of different things pop up. Some of them are specifically PT clinics using this kind of thing, which is more of an app that helps do exercise with the patient. You might start out with an evaluation through telehealth of someone, and it seems primarily for the ones that I looked at to be an orthopedic kind of protocol-driven type application. Some of them, based on what I can see on the web, you can't tell that there is a physical therapist involved, or if there is a physical therapist involved. So it's hard to know. But this was the first one that came out that, again, appears as though there may not be a licensee involved. So the FSBPT invited the, I guess, the CEO of United Healthcare or someone, who he designates to be involved in a conversation about it. And so far, they've not heard from them. We discussed this at the investigative committee and have some ideas about strategies to gathering more information first and then making a determination about what to do. And some of that involves going to try to use the app and see, at what point, if any, there is a physical therapist that you're faced with. I'm planning to make a few phone calls to some other entities who might be aware of this and, the support of its use, and then we can get back to you. But I think in general, it does say in our Practice Act that physical therapy is performed by a physical therapist, or those parts of the clinic care that are delegated. So, we would say that if there is no evidence of a physical therapist involved, that this might be, advertising in it inappropriately, that it's not really just therapy, it may be something you want to call it, exercise,
and platforms that specifically have a physical therapist on their application? What would you say to that?
Well, so physical therapists do an evaluation prior to developing a plan of care and making a treatment program for patients. And so they would have to include that. And then they might do that. And I can see that all being a part of what the board has previously considered acceptable telehealth, or care that's provided through telecommunication. But then there would be periodic checking back and, are you performing things correctly, and how are you progressing, and that kind of thing.
So
So
is
that's,
this really just they're performing actual virtual therapy?
so we don't really know. It's not.
Sounds like a healthy coach kind of thing, rather than a physical therapy. kind of
Yes,
thing.
which is another option to call it. So
Right.
calling it something else
Right.
instead of,
It's not virtual.
it's sort of,
Right.
possibly misleading the public about what it really is.
So I'm a part of remote therapeutic monitoring. So I work with, so that's just, to me, sounds like better, because you're monitoring how they're doing with their exercise program. You're not providing any therapy. You're not charging a therapy code.
And that's the other thing, it's the charging for it.
Yeah, because I know Medicare, with COVID and everything, just came out with reimbursing those types of services, those monitoring services remotely. So,
Well, and it's interesting, even in the definition and description of how this works, under the app, it's a smartphone, and AI technology analyzes your movement patterns while performing PT exercises.
Right.
And then it says, if at any point a certified health coach is needed, one can be accessed using the in-app chat feature. Well, a health coach is not a PT, right? So they cannot call it virtual PT if PT is not called.
yeah, so I think the wording is.
Yeah, they're just trying to avoid paying for physical therapy.
Yes, you're almost,
At all costs.
Let's just not even, try to hide it.
it's almost along the lines of like a chiropractor not having a PT on staff, and saying they're doing physical therapy. It's
Doing,
kind of like
would
you
you like
said.
some therapy?
Right, but they don't have a PT on staff, so technically that's not allowed, it's kind of along those same lines.
Yeah, and again, if our job is public protection, this is a definite public protection issue. So
I think it needs a lot of clarification.
I'm glad that the FSBPT has jumped on this and, is taking care of this. And that's what the FSBPT ought to be doing. So
And I was glad to see that you both signed it.
Well, and actually, I emailed them right away when I got it, because I saw that we had signed it, but we weren't really asked to sign it. But they are correct in that that is what our practice act says, and I think we could easily support that.
right.
And I can give you some resources too, you need from
Sure.
some other platforms along those lines.
Thank you.
Particularly if that's where a lot of insurance companies are wanting to go to divert care and funding for.
So that was the update that we have for you right now, and then I'm sure we will continue this discussion at the next board meeting.
And then the final point in that scope of practice was definition of PT and mental health.
So I got a really interesting question, and this was like yesterday or the day before, so I thought I would share it with you. And if you click on the one that says draft response, that both things are right there. And so this person was applicant communicating with Debbie about doing the jurisprudence. And what the question was, I am very excited because I was not sure if mental health was recognized as part of PT services, but she noticed that it was part of the definition. So the very first thing, and then she goes on to elaborate on all these things that she does that she's wondering if it's going to fall within mental health. So first thing I do, go back to the practice act and look at the definition. So if you scroll up to my answer at the top, there you go, right there, David, the box where in the yellow where it says physical therapy means all these things for the purposes of preventing, correcting, or alleviating a physical or mental disability. That's really different than mental health. And so this is a draft response. I haven't sent it yet because I don't think I've ever received this kind of question. But, so first I provide her with a definition and then, elaborate that the practice act refers to mental disability as it relates to the scope of practice that physical therapists treat. We're not doing mental health therapy, it's, you know, like brain injury or, you know.
Wasn't that her question, we should bill for what she was doing, rather than having his past ways?
I think that's reliable.
And she's not yet licensed in North
Right.
Carolina.
So it's great that she's asking the question because we can clarify that right up front. And then, you know, I provided her with, under the rules, it states more specifically what is within the scope of practice, so she can, you know, kind of put it all in context and then answers. If you got additional questions, to let me know. So, you know, if you'd like, I can add more to this answer before I send it. I just haven't sent it because I thought.
The only thing I just is that, with it, don't we have a sort of a standard disclaimer that for this?
We don't do reimbursement.
Yeah.
Yes. Okay. And we don't respond to reimbursement questions because we don't have authority over that, over payers or payer policy.
Could you also like give her an example as mental disability being a TBI versus mental health being whatever she's stressed or emotional, you know, so that she doesn't go, oh, mental disability, you know.
So she works with pediatrics. So
I just worry about her coming back and saying, well, technically this is a mental health issue. I don't know.
no, I hear what you're saying, and that's partly why I didn't elaborate on it, because, you know, I can put down diagnoses all day long, right?
Not all.
It's true, great.
Yeah, that's when you work hard. I mean, you can make an argument that there were studies using Botox that decrease depression. Because people are severely depressed. When people are severely depressed, they have to go to scientific work. And so they did study with Botox. Showed that they started feeling more energized. But even with that study, you couldn't really deny it. I mean, you can build it. Again, most I would think of IGP. Physical disability. Analysis that's usually done.
Yeah. Well, I would try to do a couple of those clarifications and then respond to her.
Well, it's interesting, our last question is, I'll be getting my North Carolina license soon, wondering if my stress management and emotion management services can be reimbursed by insurance companies. That's her biggest question.
Right.
That's why I just thought it was just saving another, the next thing they offer.
Well, that's
if you
true.
press
That's
it
it.
down.
Got it all out on the first
Yeah,
one. Yes,
yeah.
that's right. That's right. And that's true.
It's a long.
Thank you.
Okay, that concludes the section on scope of practice questions and board response. Is there any further question for Kathy on anything that you read there? Hearing none, we will move on to our attorney's report. David Gadd.
Okay. Just a couple minor things in the general update. The contract with the North Carolina PHP Professionals Health Program is finalized that we discussed at the last meeting. The copies are fully executed and we have a licensing enrolled and everything seems to be going great. One benefit to this is that the board has needs for referrals for professionals in that area for other things, particularly related to the investigative committee. So it's nice to be able to shoot an email to those folks and they can say, here's who we suggest you contact. So it's really provided us with an excellent resource to not only refer licensees to them, but to get names of professionals who may be able to use.
Would you please circle back and tell us the name of the company again and
Yes.
what the initials stand for?
Yes, the North Carolina Professionals Healthcare Program. And they provide support for mental health, substance abuse related health issues, primarily to healthcare related licensing boards. So medical board, dental board, there's some other boards that use the
Medical board, the pharmacy. board,
Pharmacy
that-
board.
that board.
So the other boards, I think, have more licensees and more licensees enrolled in that program. But they've been at it a long time and are seem to be good at what they do. Provide us a high level of service so far. So
That's great.
The second thing on my list is, and the board may already know this, this building has a new owner, so we have a new landlord. And one of the things that I briefly reviewed and that will be being put in front of Teresa today is an estoppel agreement regarding our lease, which basically just says that, we're not aware of any sort of breach in the lease. Everything is as it should be. Here's what our rent is. Everything is in good state of repair as far as our space. And there was a meeting held with representatives of the new owner a few weeks ago to kind of go over some things that our concerns. So they've shown like a willingness to listen. And one of the things that David and I mentioned this morning is the expansion of the Wi-Fi in this space, which seems to be working well. So that's good news, I believe. That's it for my general update. As a legislative update, the General Assembly's been busy in this short session to file a bunch of bills, none of which are extremely applicable to us, but there are some that have kind of ancillary effects. So I'll go over those briefly. One of them, and this really doesn't really apply all that much, but it's interesting. I think there's a bill, Senate Bill 435, that requires notices from cities and counties when various states of emergency. It made me think of how are we going to deal with those folks in North Carolina that issue temporary permits to practice in North Carolina based on our statute. Again, these are filed bills. They haven't been passed yet. House Bill 327 updates the process for legislative review of rules and technical changes. It added the definition state agency licensing board to 93B, which defines us as a licensing board. I'm not sure what they were trying to capture there, but it really doesn't affect us.
Since we're quasi-state, and some other ones, sometimes there's confusion about who's really a state agency or not.
House Bill 264, Emergency Powers Accountability Act. This is based on that kind of constant friction between the governor's office and the General Assembly about who and when can a state of emergency be declared. So this bill would require that before a state of emergency is declared by the governor, the Council of State has to concur in that. Of course, that was already vetoed by the governor, so it's back in committee. And that's where it sits at the moment.
And just for clarification, David, the state of emergency, that's here, and a public health emergency is under that umbrella.
A public health emergency as defined by the governor. That's a good question. I mean, a state of emergency is a term defined in the statute, and whenever the governor declares certain things, you can say, okay, we're under a state of emergency for X number of days, or like the one we're in now, we can just be open. So, I don't know if that public, would you say public health?
GHG, public health emergency.
Yeah, I'm not sure where that's defined. I can look it up.
There is something in the, either the Rules Review Commission or OAH, because if you want to do an emergency rule, it has to be related to one of these X number of things. One was a public health emergency, like COVID-19 or something like that, but then I guess to become a state of emergency, there's something else that has to be.
Right. So it's a more specific definition, and I'm guessing that the two don't necessarily have anything to do with each other. You could have a public health emergency, but the governor may not have declared a state of emergency. Sure. House Bill 195. This one's interesting because it's a bill to expand the criminal statute in North Carolina to include knowingly, willfully destroying, altering, or falsifying medical records. And that's already a violation of our Rules and Practice Act. So I don't think that it would really change how we potentially discipline licensees if they were to do that, but it just adds a layer of illegality that could be prosecuted in criminal court if medical records are falsified, altered, or destroyed. House Bill 149 deals with improving access to care through telehealth. And at first, I really thought this was going to be something we needed to really monitor, but essentially what it is an insurance statute. So it doesn't address our licensee's ability or authority to provide telehealth. All it does is defines insurance requirements and the fact that insurance can kick in when telehealth is provided in addition to any other services. House Bill 103 is automatic renewal of contracts. This is kind of a consumer protection bill. It provides that whenever contracts have an automatic renewal provision in them, that you have to have them in. Essentially, it does away with teeny tiny fine print. It has to be a 12-point bold print. So this could potentially impact us in our dealings with contractors or anything else that board contracts to do, but that's not very concerned about that. House Bill 64 is the Government Transparency Act of 2021. This doesn't directly apply to us because we're not, we don't fall in the definition, but I wanted to mention it because I think we're doing this anyway. It requires that whenever a public agency promotes, demotes, dismisses, transfers, suspends or separates from an employee, you essentially have to give a reason why. There's already a requirement that you have the employee's name, address, start date, salary, and some other things on record, but it would allow to be a public record for the reason for those things that I just mentioned. And again, that hasn't passed. It's just a sitting committee. One thing that has passed that I would have to ask Debbie or Kathy if this will really have much of an impact on how things are done in the board office, but there's a slight change in the reporting requirements about applicants who are active duty military or military veterans. It requires that the board report those who are not only active duty military, but it expands it to with military training period, meaning veterans as well. So there's a slight expansion of what we need to report to the General Assembly.
We had already, I think the board had already approved the fact that we were, because it wasn't defined like 93
was changed. We already defined military as military trained, active duty military
it's already-
spouses, veterans, veteran spouses.
Okay. So
We're
we've
we're
got-
all,
Correct.
we're covering it all.
So no change in our internal procedures there. And that is it for the legislative updates. Moving on to disciplinary. Does anybody have any questions about any of that? Disciplinary matters. So we've got two matters coming on before the board today, one of which will have a visitor on, a guest around 1 o'clock, and I'll start with that one. And just to kind of give you the background of what we'll be doing today, our board rules provide that whenever the investigative committee makes a recommendation to the board that somebody be placed on probation or receive a letter of warning, that licensee have an opportunity to come to the board and talk to you about that recommendation. So they can, just it's called in the rules an informal meeting. And so what we as the investigative committee have recommended is a quasi probationary recommendation. So it's all probation, but in it is an element of suspension along with a bunch of other things. And this is a matter that was addressed at the last board
I think it was the board before that.
board meeting before that, right? So what we did was we adopted a consent order, which was executed in full by everyone. And in that consent order, there was no active suspension. And I'll go over the requirements here in a second, but the underlying activity that brought us to this point was the licensee performed, he was a relatively new graduate, he performed dry needling on a patient, and which resulted in the thorax. The patient, before the dry needling occurred, there was a discussion about pneumothorax being possible, brought to his attention by the patient. And we essentially, the investigative committee made the recommendation based on essentially not being prepared and having proper training to do what was done, which is what resulted in this injury. So the consent order was this, suspended for a period of 18 months, and that suspension was essentially stayed upon the following conditions. So there wasn't an active suspension as long as the licensee completed advanced courses in dry needling, which covers all parts of the body as approved by board staff. Complete 50 hours of supervised mentor dry needling practice under direct supervision. Submit a letter to the board stating who the supervisor is, what their dry needling credentials are, and that they've agreed to supervise and provide a log of the training hours. Not perform any dry needling other than supervised dry needling. And remember that requirement for a second, because that's the most important one here. So I'll say it again, not perform any dry needling other than supervised training dry needling until items 1 and 2, the courses are complete and approved by the board. And then the supervisor shall review his treatment notes and submit monthly reports to the board. So it anticipated some back and forth with this supervisor. It goes on to require a continuing competence course on documentation, pass the North Carolina jurisprudence exercise, reimburse the board for expenses. And that's it. So that was executed in the winter. And then I don't have the days exactly, but a month and a half or so later, after the consent order was signed, Captain received an email from the licensee which stated, I was meeting where I was seeing a patient, and I didn't have the supervisor present, and I performed dry needling. And he had some negative reaction to that. And he did, or
The patient,
the patient had some negative. It wasn't a pneumothorax, there was some, I have to rely on, yeah, some nausea, some,
Kathy, am I allowed to say or nothing?
David, that's a question.
yeah, so Jamie's on the investigative committee, and she has to accuse herself from this conversation with him today, but she can provide some facts as it comes from the investigative committee.
So the first patient that brought him before had a pneumothorax. And so that was the negative outcome that brought him before the board. We implemented all these things. He did dry needling on a second patient who had some symptoms that it might be a pneumothorax and had to be examined. It turned out that it was not. However, it flagged the fact that he was practicing without the supervision that was needed.
Did the second patient make a complaint or
It was self-reporting from the licensee.
How about, because his workplace required him to do that.
I think he self-initiated this
He
report,
did.
but he included his employer and supervisor in the email directly to him.
So at that point, we discussed it immediately with the investigative committee. And so where we stand is that the first consent order is still in place because the board has to do something to either revoke that or whatever. But there's an additional recommendation now based on the violation of the consent order. And that additional recommendation is what he wants to speak to the board about today in the informal meeting, and I'll tell you what that recommendation is. So the recommendation to the board would be that the consent order that was made effective in February would be abandoned. The board would suspend the license for a total of 36 months, but that 36 months would be stayed for the following terms and conditions. Would be an active suspension, so no practice whatsoever for 12 months. So there'd be 12-month period where licensee would not be able to practice any physical therapy. So for 1 year. Following the 1 year active suspension, no dry needling at all for a period of 18 months after that. After the 18-month period of no dry needling, and before resuming any dry needling unsupervised, a completion of 50 hours of supervised training in dry needling. Supervisor would have minimum 5 years of clinical practice experience, demonstrate completion of 50 hours of continuing ed of clinical practice in trigger point dry needling, have 2 years of clinical experience in trigger point dry needling covering upper and lower extremities in appropriate areas of cervical and lumbar spine. Resubmit a log of supervised trigger point dry needling showing hours and description to the board on a monthly basis. Agree to be responsible for any dry needling performed during the period of supervision. And the next requirement would be that the licensee will have to successfully complete the probe ethics and boundary violation course and receive an unconditional pass. Licensee would pay the cost of the investigation, which includes the cost associated with previous consent order. So at the end of the day, you've got 12-month no practice and then 18 months of this probationary sentence on top of that, which would require fairly extensive supervision.
If he took the first option, what's the first option? No he couldn't perform treatment for 36 months.
Well, the 36 months is just the full probationary term. So inside that 36 months, you have 12 months of nothing.
I see.
And then after that, you have 18 months of all of those requirements.
Okay.
So that would be our our suggestion. Of course, the board doesn't have to suggest that. And doesn't have to adopt that. It's just a suggestion and a recommendation of the investigative committee based on all of the, all the stuff that we gathered speaking with them. Today's meeting is purely informal, so you, the board, can ask questions. I thought what we would do is allow him to speak and let you listen, and then ask any questions that you have. And at the beginning of it, I can kind of, I'll make an introduction and just go over what I just went over, so we can kind of have the basis for what we're talking about. And then you can, we don't have to make any sort of formal decision today. In fact, he would have the opportunity after today to have a formal hearing. But the rules require that we need to go through the step first.
Does he have representation by an attorney?
We've asked that, and so far I'm not aware. So I think it will be just him. If he does have a lawyer today, it would be a surprise today.
What's his current status? Is he?
He's not working. He was terminated as a result of this second.
Okay.
That's kind of it. Any other
Did
questions?
you want to ask him or tell them about his requests about, what's my question, federal facility?
Oh, he did email what the requirements were as far as if he worked on a federal facility, would he need to follow through with all this stuff? And the answer is, you have to be licensed to work in a federal facility, and we can't monitor that. That would be up to the federal government if you worked on an army base or something.
Would they look at?
I don't, yeah, my guess is they wouldn't, they wouldn't ignore this,
Right.
but I don't know what their process is.
And the reason for that is that as a state board, we have authority in a federal facility, but yet they can't hire him unless he has a license from the state board.
Right.
And currently he does have a license. Is it suspended currently?
No, it's under the restrictions of the first consent order.
Federal government is pretty stringent. But issue a license on really the practice, whether you need regulation or clinic. So he's in this status of a shop. I would just- we can,
I guess we'll be able to ask him the question, but when he made the decision to do the dry needling without supervision, was there someone else available or?
And I don't know.
I mean, right. And I would like to ask the question to the investigative committee, just because I was on it for several years. The fact that he self-reported, how did that influence your decision-making in terms of his discipline?
I can let Jamie or Catherine.
I can answer for myself and Jamie should answer for herself. I hesitate to bias you, but I think that my general impression about whether he understood why he was being disciplined and his real response to that never felt to me like he really got what we were trying to say. And so as a result, yes, I'm glad he self-reported, but it doesn't really have an effect on my not wanting to take another step forward, a more stringent level of discipline.
And I might still, he did self-report immediately to the supervisor. If you can check, but because this guy had a potential injury. And they said, well, thank you for reporting. You're gonna have to tell the board because the supervisor now could be in trouble. And he did report it all immediately. But I think it all came out mainly because the issue, he was caught. And because of the injury, and had that not happened, it probably would have just slipped by, because he had said, I'd already talked to the guy about fine needling, and he was reluctant to agree, so when he finally agreed, I didn't want to say, well, I can't do it today because I don't have a supervisor. He thought he would lose his buy-in, kind of, and that just did not seem like a good reason. Yeah.
And what was Kathy, were you able to look up what the reaction was? Was it?
I know,
not-
I'm still working on it for
Okay.
some reason.
I didn't
He has
know.
2 very large folders and I brought down one, but I didn't bring down the second one. So I'm looking for it so that I can get it.
So we might see this today and see him, I assume. But the fact that he thought he could do, so the first time's a fluke, right? You go, oh my gosh, it's units, it happened. We
Did he
need
have
to
training?
address it. He was trained.
Well, no, because you're saying, well, he didn't have training.
I mean, he just had the regular entry level training.
Well, but he did, and this is.
That's what I'm saying.
Okay, so this is what we initially got, was that he did an online course. Well, when we came back to him being present with us, he said that High Point University had brought in external course providers who provided to students as an elective the dry needling course that people get once they're licensed. That was what was brought, that's what we were told. And so his belief in what he was told and what he had received in school was that he did possess the advanced training to do it. And not only that, but he was also assigned to a clinical site, and I believe it was a VA, where there was a trained dry needler who was his supervisor, who allowed him to dry needle during his clinical evaluation. And this is part of this whole definition about what's advanced training. When does it happen? When doesn't it happen? That you get this advanced training. Analogous situation for the internal pelvic health. There is a student who's not only taken level 1 APTA, they've taken a level 1 vermiculite course. They're ready to go out and do is what they believe. But if we're making decisions for the full licensee population in the state of North Carolina, it's not available to everybody in entry level education. So it's still it's hard to decide what we do, but we've been pretty clear that you shouldn't have been doing this at this point.
And did any of that training he had as a student, did they bestow upon him any sort of certificate as a DN1, a competency? Was it just a student opportunity, like an internship or something?
Well, so I think it was part of this clinical internship. Because the board does not recognize certifications of any sort, dry needling or otherwise, and it's not a requirement in the rules that anybody possesses it, they don't have to have that. But, the board has, I think, been under the impression that you don't start doing advanced things until you're licensed to it. And that's where the rub is coming with some of these things.
That whatever you take as entry level is entry level.
Right.
And not advanced, because you can't get advanced until you've done your entry level.
And in medicine, you get your full active license. That's what, internal medicine. What you have, 5 some cases, 5 innovation, sexual research. Got to sign on, right? There's plenty of opportunity, but you got to sign on.
That's the clarification.
So that was,
Yeah,
yeah.
that was.
So
that's a big
if you were
difference.
trained, then it might be an accident, but since the training didn't happen, or then it's, maybe now we realize, okay, I don't know what I'm doing. And I need to go for further, I don't know.
Any other questions about this gentleman?
I can read you something that's going to clear this up
Go ahead. Okay.
So, very first, he acknowledges that he did dry needling without the supervision, and that he had been discussing this with the patient, thought it would be beneficial for him, and the patient didn't agree to it initially, but then agreed to it. So these are quotes. I foolishly and egotistically decided that it was in this patient's best interest to have this intervention performed without my required supervision. When needling his upper trap muscle, the patient communicated to me that he wasn't feeling good, and I stopped the needling. The patient had a few bouts of light emesis and reported some nausea. I sat him up and gave him water and monitored his condition. The patient denied shortness of breath or chest pain. After 5 to 10 minutes of monitoring the patient, he no longer reported any nausea. The patient demonstrated his well-being by performing light banded postural exercise that we had performed in the past. After some more monitoring, I felt comfortable sending the patient home and concluded that he experienced a strong sympathetic nervous system reaction, which is not unheard of with dry needling. 2 hours after the session, I contacted the patient and he informed me that his upper traps were a little sore, but no symptoms of shortness of breath, chest pain, or nausea. I plan on following up again tonight and tomorrow just to be safe.
But for him to make that first comment, he knew he had a choice there. So that's the.
Well, let's see what it says today.
Yeah, just so I'm down with providing balanced information. He discussed it with his employer, and all the hierarchy discussed it. Together, we think it was best if I personally brought this to your attention. I broke their trust and the trust of the board. For that, I am extremely remorseful, and you have my apology. Yeah, I think it kind of goes on to say that.
Let's move on, David, to more regulatory education. Or did you?
We've got one more discipline.
Oh, I'm sorry.
That's okay. So the second matter, the licensee will not be for you today, but we have a recommended consent order. So I'll go over that briefly. This licensee, there was a complaint submitted over 2 years ago, February 14 of 2020 was when the allegation occurred. The allegation involved impairment at work from alcohol. The licensee, according to folks who were there, worked in a hospital setting that day, acting unusually, staggering, bumping into things in the office, and there was a long list of patients for him to see that day. So the supervisor and the other people there at the office were at the hospital were concerned, and after showing that concern, he left the facility abruptly, leaving the patients on the schedule and everybody to see them. So he then called back or maybe emailed back and admitted to his impairment from alcohol at that time, and that he had an addiction problem. So he was then referred. The reason why this has some age on it is because he was immediately referred at that time. We worked with VHP. We had the North Carolina Alternative Program for Chemical Dependency, which was administered by the North Carolina Board of Nursing. He entered into that program and remained in. There were some challenges, but he remained in good standing with that program until June, at which time he asked if he could be transferred to Virginia because he had a job opportunity there that he wanted to take. So we went through this process with the Board of Nursing to have the agreement and the contract in North Carolina terminated as long as he could pick up a similar agreement in Virginia, which provided for the same credit, which was supervision and chemical addiction program that he was going through in North Carolina. He picked up there, so he did that. He was in that program from March 2021 through about August 2021, at which time he informed us that he wanted to move back to North Carolina, terminate the agreement in Virginia, and that's kind of all we heard at that point. And later on, we were figuring out what to do, and whether we should pick back up with the program in North Carolina or proceed in the investigative committee the usual way based on the complaint. We learned from Virginia that there were pending complaints there. And so, interestingly enough, though, they didn't really have anything to do with substance abuse. They were mostly boundary violations. A couple of them were sexual advancement type violations, sexual in nature, stretching of the patients beyond their comfort level, causing extreme discomfort, crying, that sort of thing. Those allegations have not been finalized there. There's a pending administrative hearing at the end of this month about that. He was administratively suspended based on, I think, a lack of response and also the nature of those complaints. So he's informing the board, this board, that he doesn't intend on ever going back to Virginia, and he's not so much worried about the status of his license there as he is here. So, we don't have the authority to investigate what occurred in another jurisdiction. We can take their reports as they send them to us and determine whether or not there's been violations there that would be a violation here, and it's discipline based on that. But those haven't been finalized yet. So what we've come up with is based on his violations in North Carolina when he was working for the hospital. And we have a consent order for your consideration. And I'll, before I go into the recommendations, I'll allow Kathy or Jamie to add to that if they like, in case I missed it. The board recommends that this is similar to the last one as far as the way it's structured. There'll be a surrender or a suspension for 24 months, commencing on immediately when the order is signed. And that 24 months is, there's a 24-month period of active suspension. And during that 24-month period of active suspension, you would complete the ethics and boundary violation course and receive an unconditional pass. Obtain a fitness to practice evaluation from a board-approved addictionologist who will receive information regarding the case and report findings and recommendations to the board. Licensee shall comply with any treatment recommendations of the addictionologist to the satisfaction of the board before returning to practice. Licensee shall be required to execute releases enabling the board to communicate with any professional treating him to discuss his compliance with treatment recommendations. Should licensee wish to change providers at any time prior to approval, the board has to weigh in. Has to demonstrate proof of ongoing sobriety to the board and treatment providers for the 24-month period by documentation of negative drug screens, alcohol, or other substances as required by treatment providers, and at a minimum of monthly. The drug screen provider shall be approved by the board. After the 24-month period of suspension and successful completion of the above requirements, the licensee may resume the practice of physical therapy with the following restrictions for an additional period of 12 months. And one, clinical practice shall be supervised by a board-approved supervisor. Licensee shall keep the board informed of his place of employment and provide the board with certification from any employer that is aware of the conditions of this suspension and agrees to comply with them. Supervisor shall submit a monthly report indicating no evidence of substance abuse or impairment, no patient or staff complaints, appropriate clinical practice, physical therapy, and appropriate documentation. Submission of monthly drug screen results, alcohol and other substances indicating no substance abuse. And then if any time he's not actively practicing, the term of the state suspension shall toll until he's done these things for the period prescribed for a total of 12 months. Reimburse the board for the cost of the investigation. Comply with all requirements of the board's rules, including to keep the board apprised of its home and work address and promptly respond to any inquiries from the board. Violations of well, let me back up. A violation in Virginia based on past actions would not serve to revoke this order because we know about it. We've crafted it in such a way that we think would be more beneficial to his rehabilitation than just a pure suspension. Because eventually he would be able to come back and then not have done all these things. So that's kind of how we finally come up with this. And that's it. That's a lot.
So if he gets, if during the course, if he accepts this order and it moves forward, and then in the course of that, Virginia issues its own discipline, does he have to comply with the Virginia rules to get to North Carolina?
No, so he could be suspended in North Carolina. I mean, in Virginia, he could be suspended there. And then he can enter into this consent order and practice in North Carolina, and this would apply, despite a suspension there.
If they have other terms, that is irrelevant.
Right. Unless he moves back to Virginia, then he has to
Okay,
apply.
I just didn't know if that had any bearing on the terms of the length of time.
Right, and I think Virginia's just gonna suspend him outright, because I think what he's indicated to me that he doesn't intend on even dealing with them at all, not even going to the hearing or anything.
Does he live in Virginia right
He lives in
now?
North
He's in
Carolina.
North Carolina
He's
now?
not working.
Gotcha.
He lives in North Carolina. What he said is that he wants to work here, doesn't ever want to live in Virginia, and he wants to eventually get his license back. And he can't, under this, he's out for 2 years. Then he has to do all this stuff. Then after 2 years, he has to come back and still be supervised and comply with all these requirements. So our hope was by doing it this way, we would assist him in rehabilitating to the point where he could be a functional practitioner.
Need a board vote to accept your recommendation of this consent order.
Yes.
Having heard this explanation from David and any input from the IC, does anyone have any questions or concerns or editorial requests or comments for David?
So I just have a question. If, he goes through the whole process and let's just say that there was another complaint, let's say 3 years down the line, like it would be brought back to us and then you kind of walk me through that. Like, is there like a three strike thing or no? It's kind of just based off of.
Yeah, it's in your discretion. You can, with each additional violation, you can suspension, revocation of the license. You can place additional requirements to address whatever that new complaint is. It's kind of why that is part of the board.
It would just be curious to see if the violations, boundary violations. So, curious to do that. Not to excuse it, I'm just curious that if it was, now we need more care into this.
I think it goes beyond the substance use potentially, and their covenant. I'm going to say allegations or inferences that it has some health issues as well. But that was not a part of it. That we were requesting here.
So when he came before the investigative committee, what was his? Did he accept responsibility or?
As to the North Carolina stuff he has, he says he's got issues with what the allegations are. And, you know, one of the kind of reservations I have is that he hasn't had an opportunity to address those, even though he says he's not going to. So legally, we can't really push him for that at this point because that he hasn't had a hearing. He hasn't had an opportunity to go through that due process there. But he says he does have issues with the allegations there, but as to the North Carolina complaint, he has owned up to it. He did go through the
As he said, he was doing that for like a good year or so,
program.
a year before he moved.
He also worked in the hospital for many years with no issues.
Well, no issues that were reported,
That were
and I
reported.
think that's fair to say. Because when Mark did an additional investigation after we learned all of these things, then there were several people who said that they would never want to work with him.
No formal complaints.
Yeah, but no more.
I'll entertain a motion to accept the IC's recommendation on this licensee.
Kessler, limited, except we asked this recommendation, yes, are always thorough and honorable. So
In other words, I'll second.
Motion been made and seconded to accept the IC's recommendation on this licensee. Is there any further discussion before the vote? Hearing none. We'll start with Megan. You'll say your name, aye, nay, or abstain.
Megan Wentz,
Aye.
Jamie Meyer, abstain.
Paul Mercy, aye.
David Edwards, aye.
Teresa Hale, aye.
Rosanna Gonzalez, aye.
Leslie Kessler.
Stephanie Bernard, aye. Motion carries. Thank you. And thank you to the IC committee, because it takes hours to come up with these recommendations.
And I appreciate the investigators consistently looks as to how to help the person. Versus just take that their approach and say, do appreciate the thoughtfulness. of the consent order to protect the public while also. Licensing.
So moving on to the next item on the agenda, regulatory education. I'm trying to decide what topic to address. There were, and there have been through the course of the pandemic, questions to the board about how to deal with the various guidance from the government, whether it be the federal government, the state government, the governor's office, on how to deal with mask mandates, particularly as they apply in clinics, and what sort of guidance we'll be giving our licensees on how to deal with that and how to navigate all the different instructions coming from different places. And what seems to be kind of the easy way out, even though when you kind of dig down into it, which I want to go over today, what the analysis is. What seems to be the easy way out is what the board has done, and that is to suggest to our licensees that they follow the guidance of the governor's office and what's been presented by both the CDC and the North Carolina DHHS. And the reason that seems to be the easy way out is because we haven't come out with a statement saying do this And there's lots of reasons why we haven't done that, and that's kind of what I wanted to go over. But just backing up to what our duties are and what the board's powers are as laid out in the Practice Act. I wanted to go over those real quick. So the Practice Act and board rules are pretty much geared toward the regulation of licensees in their practice of physical therapy and not in how they develop policies in their clinic. And the board gets its authority to act and to regulate licensees from the Practice Act, which says the powers of the board are as follows: examine the qualification of applicants, issue, renew, and revoke licenses, conduct investigations for determining whether violations of the article exist, assess continued competence, employ personnel to carry out the provisions of the article, conduct administrative hearings, appoint members to act as representatives of the board, set fees for applications, adopt, amend, and repeal rules, request DPS to provide criminal history record checks, issue subpoenas, establish programs for aiding the recovery and rehabilitation of licensees who experience alcohol, chemical addiction, mental health problems, and acquire, hold, rent, encumber, and deal with real estate for purposes. And going over those, it's hard to fit any kind of clinic policy into that. It's really geared toward dealing with substantive physical therapy and whether we can discipline licensees for failing to follow governmental rules, orders from the governor aren't a good fit in what our Practice Act addresses. And the powers and duties enumerated through what I just went through are really enable the board to safeguard the public health, safety, and welfare against unqualified or incompetent practitioners. And again, it's not really geared toward clinic policies. So in looking at, we constantly have questions on, well, I know that this practice across town is allowing people in their clinics and not requiring masks in violation of the governor's order. Why aren't you going after them? It's kind of some of the questions we've got. So really what we're charged with is determining whether there's been an act of malpractice, gross negligence, or incompetence in the practice of physical therapy, is what the board will say. Or if there's been conduct which could injure or harm the public. So that in kind of the analysis of this, it kind of falls into, okay, well, maybe if they're not requiring mask in violation of the governor's order, maybe that could harm the public. Maybe that's what we pin this on. We can follow through with some discipline. The problem is those governor's orders don't directly address licensing boards to oversee them. The responsibility in the orders themselves fall on the businesses and the local law enforcement to enforce. And the orders themselves provide for civil penalties for failing to follow them. They don't say they're a violation of any Practice Act. They don't say they're a violation of any board rules. And then to further complicate that, at least 15 sheriffs in 15 different counties in the state publicly came out, I don't know if you remember this, and said, we're not enforcing this. We don't care what the governor's rules say. Yeah. So which further makes it more difficult for us when we've got licensees across the state to equally enforce, because if 15 sheriffs, the way to get somebody to comply with this is through the sheriff. 15 of them have said we're not going to do it. It makes it extremely difficult for us to apply. And from what I could find, at least the 7 most populated counties in the state, which are Mecklenburg, Wade, Guilford, Forsyth, Cumberland, Durham, and Buncombe, those sheriffs in that county have issued 0 citations. which again, if we were to try to discipline someone for failing to provide masks in the clinic, it just doesn't jive with what's been going on in the state. So that's a further problem we would run into. So in addition to the state, the counties can also issue mask mandates. And in those circumstances, it also falls on the sheriff to follow through with enforcement. So it would be essentially a violation of a county or city ordinance that they can charge the person with. So then I started thinking about, well, what would it take to make it to make the board able to enable the board to essentially order our licensees and discipline them for failing to follow the mask guidelines. And so I really all I came up with was three things. If the governor's orders specifically said licensing boards, you're charged with this, then I think we would have the duty. I also think that if our board, not that we can pass it, but I think if our board adopted a rule and went through rulemaking, then I think we can do it. Because that provides all the due process necessary to follow through. And then finally, if the General Assembly passed a law, some of these laws that they passed in relation to the pandemic, if one of them required us to follow through with mask mandates, then I think we could provide discipline for licensees not following the governor's orders or the General Assembly. So that's kind of the state level. And then what even further complicates this is there were different rules and guidance at the federal level. And even at the federal level, different agencies didn't have the same rules. So federal healthcare facilities such as VA hospitals, military bases, and federal prisons, they had rules adopted by the Federal Department of Labor. And those rules adopted by the Federal Department of Labor conflicted with the rules of OSHA. So there were federal OSHA rules that applied to private employers that weren't consistent with the Department of Labor rules regarding masks. Particularly after vaccinations came out. There was some, then you throw the CDC guidance in there too, which was slightly different. But the CDC, after vaccinations came out, said that fully vaccinated people can forget about wearing masks and social distancing in most activities. Well, that's not what OSHA said. OSHA said you had to wear the mask in certain workplace environments. So, I mean, as I was kind of trying to figure out how we could deal with this, where I kind of was led to was that we really weren't, our government at all levels really wasn't prepared for this. There's all layers of bureaucracy that the different agencies have to go through to have these rules adopted. All of them went through at different speeds and considered different things. At the end, they all kind of had different guidance, which makes it almost impossible for us to evenly apply it to our licensing population. The other licensing boards had the exact same problem. I'm not aware of any licensing board in the state that required that had mask mandates as a requirement with discipline at the licensing board level, and basically left it up to employers to deal with it. And there is one exception. I think if in our board rules, it requires that our licensees provide a safe environment for patients. I think if the situation came up where it could be proven that there was obvious ignoring issues and health care precautions in a clinic setting to where it was completely unsafe for patients, then I think we have something. But that's not typical, that's not purely related on a mask mandate. You would have to take in all the facts to determine that. There were different definitions of what a healthcare setting was at the state level and whether masks were required in different counties had different mask mandate requirements, and even in Wake County, all of the individual towns and cities had different requirements, some of which relaxed their mask mandates at different times. I know as of February of 2022, Raleigh, Garner, Fuquay, Knightdale, Roseville, Xavier, and Morrisville ended all their mask mandates, while Apex, Cary, Holly Springs, Wake Forest, and Wendell are still going on for a period of time. So all of these different layers essentially made it even more difficult for us to be able
Just like
to.
we can improve our income so much. If we could figure if the PT board could figure out how to make this all work and do this, then we can sell it to everybody else in the world. But no license fees forever.
And then finally, you've had all this political toxicity around the whole thing. That even if you did try to come up with some sort of rule that applied to everybody, the way our politics are now, it would just be an internal fight, and that one that we probably would not want to get into. So that's my report on the reason why the board did what it did as the mask mandates. It was just an extremely difficult thing to try to navigate based on all the different guidance from the different government levels.
It's always changed.
And it's always.
Right.
I mean, there was a study out of Kansas so that masks actually increased your risk.
Right.
Because you actually inhale the same, I mean, you take basic microbiology, stands for solution. You gotta have a certain amount or not to actually get effectively. So, and the thing we did to the kids, that's even. Forced to be passed. They a lot of money not to communicate that. They don't have, it's not the same. Right, so they changed that, and then with the vaccines, that's.
What,
It's just not consistent.
so what are you telling, so you're getting complaints, you know? What are you, what's your response? Like, what should we tell them? Like, what are you telling them?
I just sent them back.
Yeah, I-
Right.
That's something else.
I got a number of this.
Yeah, I can tell them what we have said, and that is that we support the current governor's rules about mask mandates, in addition to the CDC and the DHHS guidance. But the underlying obligation that they have is to ensure that the environment for care is safe based on that guidance. I think that's how we, which is not very specific at all, but it's kind of the best.
But I will say there are a lot of people that are unhappy that we're not helping them because they sort of need that additional backing to help make the policy in their clinic, whether it be for patients, their staff, whatever. And I totally feel their pain. It was very hard to come up with something to say, and I couldn't have done it without David. So
Okay, thank you, Devin. I, as a one small example, had a parent of a child in our clinic. We have a mask mandate. You walk in the door, you need a mask on. And the parent cussed out my front desk receptionist and just went on this long tirade about, you know, every mask this and that, the other. I'll separate at 6 feet and all, you know, but you can't make me go wait in the elevator lobby. And it was just horrible. And the poor front desk receptionist is the recipient of this anger. And so, you know, I had to step in and ask her to walk out to the elevator lobby with me. Let's have a conversation. And, you know, she just was not satisfied. And acknowledged, I understand every medical practice is requiring a mask.
I mean, the CDC recommendations are just to wear them. So we even as home health clinicians have to, our patients physically get mad at us for wearing them. And I'm like, ultimately it's me protecting you. You decide not to wear it, that's up to you. But we technically have to wear them. So I cannot take this off. And they're like, well, I can't understand you. I just have to say, I'm so sorry. Like, I'll do the best I can to convey what I'm trying
You're
to
being
do.
compliant with your employer's mandate to keep you all safe, right, and keep your patients safe.
And they're all fronting on this easy curriculum. My past clinic is outpatient and they still have it. I mean, it's part of the UNC system. I really do see it still doing the CDC mandate and that's to wear masks. So
And I think people are frustrated that there's what's the threshold of mask?
Right.
Because if you say have be COVID free, that's impossible.
right.
I mean, I had it twice. So,
With it on. I mean,
yeah, I mean, so, and when we have flu outbreaks, we don't get vaccinated. Unless you're treating someone. But we did, and we didn't have to again change. So that's, what's the threshold? I mean, you think that you started. I don't care right now, but that's how you retire with mask on.
Yeah.
So that's what. What is the threshold? What are we gonna do? So I'm just getting. But I mean, that's a question that, you know, I lay around for you. What is it?
I remember the day that the governor announced relaxing the mask. Within 5 minutes, people were like, I mean, I'm not worried anymore.
right,
And we had one there, we had a couple of police on, because he was totally just doing slamming, bamming, cussing. And
I
so
should introduce him to this parent.
we've had quite a few of those. So our staff has to wear masks,
right.
period. Patients, we say, if you're fully vaccinated, it's your choice. And that's, you know, when they want to have any trouble with staff, we don't like it.
Right.
But I haven't had, you know, lashback from, you know, staff.
Yeah, it's not as simple though, because like what you said with the kids, you can't do speech therapy with kids and have masks on. Because they say how much, you know, it's watch my mouth. And I tried the one that, for my older patients that has see-through, it fogs up, it doesn't work. Because I had a deaf patient who reads lips, you know? So in that building, it was sometime, as long as one of us had it on, so she put it on and I talked to her. We kind of reversed what the normal was, but that's no longer acceptable.
How about a face shield?
We had to,
You could do both.
face shields were not considered an acceptable substitute for a mask.
Yeah, I mean, just so the patient could read your lips.
Oh, yeah, I mean, that's a good, but I mean, it didn't still comply. And I still have that ongoing, because a lot of people who aren't deaf but are low hearing use that. I back up 6 feet, pull it down. I know that's probably not right, but we have to be able to communicate. I mean, I understand why it's an issue. It's hard.
But we've seen, we do a lot of speech therapy in schools. We have physically observed kids being behind because of the mask. The development is just not normal.
Well, that's it.
My kids go to a charter school and they've been masked for a while. When the board met, I remember that night that we were not silent. We played over the joy. The board is words. Because they found my hair. That's how you look like. And it's
Yeah, it's just.
so it's just, again, I think that's what they're afraid of. There's no threshold. And has there ever been, what is it?
You can't make everybody happy, so, yeah, I mean, someone's always gonna be upset about it.
So we're all weary and hopeful about the future. So, again, thank you, David, for summarizing all the different nuances about. Yeah.
And thank you for the research.
Yeah.
You know, it is what it is.
David, was there anything else in your report?
I've got one final thing, and if I can do it now or come back to it, whatever you're.
Go ahead.
Okay, so the last thing that was in my report is, over the last few months, the board has received questions and sort of semi-complaints about foreign trained applicants and what their requirements are under 2 areas. One is their substantive training requirements and whether they are substantially equivalent to what we require when they have been educated outside the country by a program that's not captive accredited. And then the second thing is regarding the TOEFL and their English language equivalency. So, and Captain, feel free to chime in on either one of these emails, but these questions came to the board, number one, from someone who was trained in the United Kingdom. They have been licensed in other states in this country for a long time, like over 20 years, I believe. But because the way our rule is written, they were initially trained by a non-CAPTE accredited program. They have to show that program that educational program is substantially equivalent. And based on that, it is possible that this person, even though licensed in the United States for a long time, would have to take some additional training on classes. I think she specifically mentioned lacking the physics class.
And I will tell you, what they don't see is the flip side of having to make those decisions. So I think if we substituted the word discrimination for standards or something, the email on some levels makes sense, on other levels, it's not what she's describing. You know, my understanding is that generally speaking, this is the way our rules are written. So I guess I can't even say generally. Our rules are written so that if you have never taken the exam before, you have to be evaluated on a coursework tool that matches current education. If you have not had that current education, you need to obtain the deficiencies. And partly it's for the benefit of the individual who's going to take the test, because that's what you're going to be tested on. Now, I agree, and I think I see where she's coming from, that these gen eds that they are also deficient in because their educational system operates differently in another country. It does feel like, well, I've made it all the way through, I've been practicing for 20 years, what in the world do I need to go back and take these gen eds for? If we don't do that, then we're discriminating against the people in the United States who have jumped through all these hoops already. So the idea is really consistency across the board. And I understand while it feels discriminatory, I think we've worked hard enough on our rules that it's a minimum standard. You have to meet a minimum standard. And if you're applying here by endorsement, it is evaluated on the year that you graduated from the program. You are not being asked to meet DPT, CAPTE accreditation. So a good portion of her email does not apply to us. She's sending this thing to all states that are compact members because, and this is where there's something to think about, but I don't know that it will be able to be changed with the United States way of doing licensure. What she's saying is your standards are inconsistent across the board. And so you're asking me to accommodate to inconsistent standards. And you know, my fellow colleagues and I who have been educated outside the US feel that this is discriminatory. Well, with a compact privilege, you're really just being evaluated on whether you have an active current license that doesn't have discipline on it. In that way, you can get a privilege, but if you move anybody else in the United States who has a license in North Carolina and they move to California, they've got to get a California license too. And those standards are a little different. We might have to do something as well. So I think there's kind of too deep of a focus on just the foreign education requirements and not that it would be the same for a Catholic person as well. That's my take on that.
Yeah, and as far as the discrimination claim, I mean, legally, our job is public protection. We don't have any control, nor do we really know how foreign programs, what people are learning in foreign places. So even though she's been licensed here a long time, I mean, I find her situation unfortunate, but we can't apply a different standard to her than someone who's trained somewhere else and licensed here for 6 months in another state.
And just as a point of clarification, the standards, the coursework tool requirements are the ones that were in place when she graduated or first came to the US, not what they are today.
The coursework tools have been updated over time based on the general state of education. So there are now 6 different coursework tools for PTs, there are 2 for PTAs. And to take the exam, you need to be evaluated on coursework tool 6, which is the current standard. To do by endorsement in North Carolina, it's the year you graduated. So we're not really asking for anything different, but it still has the gen eds in there, and you can't just bypass it just because you've already got a license. Otherwise, it's not consistent with what a CAFE accredited person has done.
Okay, so that's my point.
I think,
Yeah, measuring her against the coursework tools
yes,
that were appropriate when she first came to school. It's not a new thing. It's a gen ed requirement that was there when she first came.
as far as I know, now, that said, I don't know what other states do. We apparently have always used the coursework tools as long as the coursework tools have been available. Other states may have had different standards, but then you're doing something inconsistently. And our motto is more consistent transparency. So everybody's got to meet these same standards. The only thing that's really different about a foreign trained person is they have to show that the education is equivalent. That's a difference. And if you are from a non-US speaking country, you need to be able to pass a basic English competency.
Which leads into my second thing. And our second kind of complaint was from an applicant who is licensed in another state and he's required to have his TOEFL, take a TOEFL to be licensed here. And in our rule, there's a built-in exception. So there are foreign countries that are predominantly English speaking, that if you are from one of those places, you do not have to. Well, this applicant was, I think, was from Korea, and it wasn't listed as an exception. However, there was an exception made in another state or something, which doesn't apply under our rules. So he didn't like that, the way that works. But, just wanted to bring that to your attention, is that in addition to the coursework, substantial equivalency, you have to have TOEFL, unless there's an exception from United Kingdom, some other Australia, some other English. I think that's it.
Thank you, David. Any other questions for our board attorney about this report? Hearing none, we'll move on to the executive director's update. Kathy.
Would you all please, at your convenience, open the board address list? Make sure that the best way that we can reach you is what is listed on here. And then just shoot me an email, Paul or Debbie, anybody, and we will get that updated. Phone number and emails particularly, just making sure that we've got the correct information. Secondly, just to echo David, the building has been, or is being sold, and so Teresa today will sign this stop on agreement. But I, in addition to this, we thought if we had an opportunity, we wanted to think about whether we could maybe update the lease some. But I think we're really probably not ready to have that discussion today. The one small question that I have is, the neighbor across the hallway from us has a psychology practice essentially, and they work also with individuals who have substance use disorders, among other things. And they're exploded beyond their current space and wanted to rent an office from us. Now, right at this point, not every office in our suite is used, but I told him that I would have to ask the board. And, once he disclosed that some of these individuals may not have the best boundaries. I felt like it might not be the best to approve that, but, you know, I needed the board's opinions or discussion or, you know, consensus on whether we could do that or not, because I wanted to be able to provide him with a, you know, an update on that. If the answer is either no, never, or not yet, or we can talk about it another time.
To me, we end up having issues, safety issues, privacy issues. Yeah.
Not ever.
So you just want to think of the office.
I think, you know, what we thought, you know, one time, like, so for example, David Knoll has the office that's right up front when you come in from the inside hallway. And, you know, that makes sense. It's right there. We got our single most uncomfortable chair in the world as a waiting room chair. And, you know, that person could come in and go to that room right there. They're not even fully coming into the suite, but we don't really have much control because we're all really in the back on the other side. And I guess I just, at this point, it might be, you know, an additional layer of complication that maybe we're not ready to take on, but it would be seeing patients in our suite, yes.
Yeah, sometimes you got a patient. Some interesting things in the office.
Would you not think though that they would have some discretion about who they would have over on that side away from their standard operating practices?
Well, that's what I thought until he described who it was that was the clinician that would be coming over and the types of individuals that he sees. Before that, I was like, why wouldn't we? You know, I mean, it'd be only a very small amount of income. It really wouldn't help us in terms of paying for our rent. But once he described that, I was just thinking, you know, I don't want to have to monitor that.
Yeah.
And get loud.
That's our exit, go out.
Yes, and we all have to use that door to go back.
That's our exit to go in and out of the restaurant.
Yeah, seeing it, I guess I have to go on to this.
Yeah. I think this is something that we can revisit from time to time. And maybe when we're ready to look at whatever else we might do with this suite on the long term, I think. And I can tell Eric Morris, the doctor that runs the clinic over there, that, you know, would have to be within a certain kind of parameter that we would even think about it. So if I were to do a straw poll, the general feeling is that the answer would be not now or never.
How many people would vote not now or never on this issue? All right, that's a strong poll.
Thank you. You've had an opportunity to look at the licensee count, and Debbie always provides that for us. And we're kind of holding steady around 3%. Last time might have been a little under and a little over 3%. It kind of depends on exactly when in the month you do it. But that's been pretty steady for a couple of months. And then looking at military permits, those are just down from a year ago. But that also probably has to do with how quickly they're being converted into licenses and timing. And compact privileges are increasing. So I think that's really good data to have because we are being asked to be a little bit more accountable from the compact commission. And I think it's good for us to be able to see that those numbers are increasing. And there are more sales of compact privileges in North Carolina. Does anybody have any questions about the licensee count? So we're back over 14,000. That usually tends to dip after renewals. We're back over 14,000. Similarly, we've got an update on temporary exemptions. Kim Jackson, who manages this for us, says now that we're kind of down to like one a week, if you will. A lot of people, she thinks her anecdotal sense of this is that people are using it as an opportunity to bridge the timing between when they apply and when they actually get their license, as opposed to really a need to work here because of telehealth or some other thing. Want to go ahead and take a break before you hop up and go back?
Well, it's almost 11:40.
Yeah. I don't know if she's ready yet.
We can, I think we're good to just have people go with the meeting and come back.
Okay, all right, that's fine.
So we or we will left.
All right, we will continue right along. David, would you mind moving to the next one for me, please? Click up. I think I unclicked my click up. Thank you. Strategic Planning Task Force. We have a really awesome group working on a strategic plan that I think that we are ready to present to you today. And just as a refresher, this was intended to be a way for the board to be more involved with the creation of annual goal setting and then the initiatives that we're going to use to achieve these goals. So David Knoll has pulled up there sort of the graphic representation of what we came up with. And this task force includes Stephanie Bernard and Leslie Kessler, assisted by Debbie Reagan and myself. So we established a vision, and if you're not able to read this, you might want to just pull it up on your individual screen. I'm having trouble reading it, so I'm gonna have to pull it up on mine. Sorry, give me just a second.
You need to click up. Thank you.
No, it's just it's not pulling up for me easily, so I'll find it in the book. Okay, so the overarching vision, and this is not going to be, overly surprising, but one of our task force members, really appreciated the real action word. We are striving through regulation to support provision of competent and ethical physical therapy services to the public. And that really encompasses our overarching mission or overarching vision for what we are trying to do. I think the word striving encompasses some of the new things that we've done, Public Protection Task Force, reviewing our rules and regulations to make sure that they are consistent, transparent, fair, and that they're meeting the minimum standards, and then what the investigative committee is doing. So we're striving through our regulation to support ethical and competent practice. Then our purpose or our mission statement, to which everything below this should be related to, is to establish and maintain minimum physical therapy standards to protect the citizens of North Carolina. This is our legislative mandate. So this really is, we've been told what we're here to do. And our core values, we looked at other licensure boards in North Carolina. One of them was the nursing board, and they're just very classy in the way that they have presented their strategic plan. And so again, it's some descriptors that are the values that we perceive, that we're proposing to the board that they adopt as what represents our core values: and accountability, ethical. I think we may need to work on a tense there. Me have to work on that, and responsiveness. So we ARE, so we're accountable, responsive, and ethical. And then what you're more used to seeing is this very long, very wordy document that lists out these areas of focus for the board and what the individual departmental goals kind of are underneath that. So what we did was we cut down all the words and we really created a graphic representation that bullets out what our plan is for the next fiscal. It's a 3-year plan, but a lot of the initiatives will happen in the next year, and then those can be updated over time. We have board performance under operations. And if you go to the far right, it's board performance, the fiduciary responsibility of the board. So this is the board, what the board does, being supported by the staff. Then outreach and education, and physical therapy practice and licensure. And PT practice and licensure are those things that are like public protection task force, licensing team, the investigative committee. And then outreach and education, or what are we going to do to put all this information about what the board is discussing, deciding, how to guide people in their practice, how are we going to get that out to the public? And that's always the one that's a little harder. And I think, we haven't fully fleshed that out, but if you look at the second bullet, evaluate public communication through additional media sources, I think, we're going to have to get to a point where we use some sort of social media, but maybe not a two-way street or a one-way street that is, letting people know what's out there. And then they can come to the website to take a deeper look. Talk about newsletters and increasing their frequency. Those will be generated by board staff, and Debbie has already facilitated a template for that. And we're working on doing that quickly. But you can read the rest of these. So do you have any questions about this, or are you in agreement with maybe some of these overarching principles, the vision, the purpose, and the values, or are there other things that you'd like to add?
I think it's very good. I think it's beautiful.
Great job. And I will say, Leslie Kessler's like, lose the words and let's get something that we can actually look at.
Thank you, Leslie. Thank you, Leslie. I guess I just have a question about the time frame. 22, the rest of 22 is part of this, right? 23, 24, 25, 26. So this is a 5-year plan.
So I'm going to admit this, I went to this meeting that talked about strategic planning, and, this big overarching plan is supposed to be about 5 years. Well, as a board, you guys are a board for 1 year. It may not be that same, and that the board next year is going to approve the same thing. We look at it every single year. I can change the date anytime.
And typically, in my experience, you kind of have like a framework that's 3 to 5 years, and then you have your objectives for, the actions for a short, a period of time within that.
And to be honest, right now, I only have enough vision that I can see a year down the road. So I think truly it really is. I can update it to
And if you historically look back at our strategic plan for the last 2 years, and look at how you've had to be an amoeba and change and move staff homes remotely. I mean, yes, your best laid strategic plan is your guideline.
yes.
And all the particular stuff that you do within that year. So it's different. So I think this looks great. Do we need to have a vote on this strategic?
I think that it would be good. You typically approve the bonus anyway. So
Any
yes.
other questions for this team that came up with this beautiful?
And this is Debbie Reagan's handiwork, this beautiful graphic right here. She is a queen. I figured that out.
And thank you for putting your vision, core mission, and values up there. That's great. Can this get posted on the website?
Yes, that is conveniently, it's gonna be easier for others to read as well.
Exactly. Any other questions? I'll entertain a motion to adopt.
Edwards motion to adopt the strategic plan as presented.
Second that motion.
The motion's been made by David Edwards, seconded by Rosa Garcia to adopt the strategic plan as presented by, I'm sorry, Rosa Gonzalez, sorry. Yes.
Just an edit, because it took me a little while to figure out ARE, and the periods, change the responsive and ethical, so that's what took me a while.
Yes, that makes complete sense. So
Yes,
fix
thank
that.
you.
And Teresa, to your point of the large guideline of like 5 years, in the written one, it does have specific dates that we have to have things done by, so the picture is not as descriptive as the words technically, it just gives the overview of it, what's working. But it does have some dates in the written one.
Yeah, although, there aren't any out through 2026.
Right.
There aren't.
Okay, are you ready for the vote? Any other questions? Hearing none, please state your name and say aye, nay, or abstain. Megan?
Megan Wentz, I.
Jamie Minor, aye.
Paul Marcia, aye.
David Edwards, aye.
Teresa Hale, aye.
Jose Gonzalez, aye. I said yes, sir.
Stephanie Bernard, aye.
The ayes have it, the motion carries unanimously. Again, thank you to board staff for putting together a comprehensive strategic plan for our board. That's really great.
The next item David already covered, we got a signed MOU. I put these things in the board meeting specifically because here it is. It's available for everybody to see, but also when somebody asks the question about what did we talk about, you can go right back to click up and we can all look at it again if we need to. So that's also there for your reference. The retirement plan trustees, I wanted to just give you a little update. Again, I included these here so that we can reference it if we need to. This is the retirement plan for your staff. And recently, every X number of years, at least 5 years, this plan has to be re-adopted by like the IRS and the federal government somehow. It's a governmental plan. And so they've just finished the restatement and readoption of this plan, and that's what's in here. And then I had intended to include the new bylaws. When I became executive director and through my term so far, I've never seen the bylaws for the plan. They have new bylaws, and that's very helpful to anybody that's coming in and wants to understand how the plan operates and what your responsibilities are as a trustee, which is the responsibility of the person that is the executive director. So that's new and updated and been very helpful to me. And there you have it for your reference. Board history. So every year, for those of you who may or may not have seen it, on the board's website, we have the board history. Always fun to go back and read it because, you forget stuff. And it really, when I go back and I read what Ben and Connie have written about the board and the things that happened while they were executive director, it's like you can totally, they painted the picture, which, I think all good documentation should do. And they painted a picture of the evolution of our board. So I thought, I haven't completed an update for this year yet. And I just thought if there were specific things that you would like to have me include, that I would just ask during the meeting today, and then I'll update it for the since February. And we'll get back to the once a year kind of update after that. There was so much that happened during COVID. That was too much. That was too much, maybe. And that's why I thought maybe you all would give me some bullet points, and if you haven't, that's okay, because I'll go from here. The addition of the Public Protection Task Force, I think, was a good one. And this is sort of addressing that issue of practice. Is important.
I thought it looked good. The only thing was that I could think of would be maybe break out the sections about a year rather than a running narrative.
Well, I think that was all 2021. And I have the dates in there, just in case. It's, again, it's more words, Leslie. I need a graphic.
I don't know.
Maybe less
Yeah, but
words.
It was, I don't read often, but you're thinking about the history of it. and everything,
Yes.
it's like, oh yeah, I remember that.
Uh-huh.
That's
We'll
right.
show you that it's a lot.
It is a lot to read. But, these are the kinds of things that really the North Carolina Archives wants. It's really what has your board done and the decisions that they have made that shapes the history of North Carolina. So that's partly why it's good. And then there's the list at the back, which is 5 pages of all the former boards that have come before you. So, and your names shall too be added. Okay. I think this might be a good time to break.
Yep. 11:42. Let's take a break and have lunch and picture guides. The lady is outside getting set up. We want to do a group shot first. That's what I did discuss. Before we like scatters or spills their lunch on your shirt.